All right. Welcome, everyone, to another episode of Get Closed, Get Paid. Today, we're going to talk about the FARBAR contracts and everything you need to know to be successful in 2025. We're going to specifically talk about three different changes in the FARBAR contract itself, plus one Condo Rider update. It's very, very important that we get these new forms, become familiar with them, and we will hopefully keep our deals together in 2025. My name is Erin Miller. I'm a real estate attorney, and I practice out of Jupiter and Naples. And I've got Kristen Jaiven. She is also an attorney. She represents brokers and agents, and also does real estate closings as well. So she's out of Fort Lauderdale and Orlando. So we kind of cover a lot of mid-South Florida. If you are new to Get Closed, Get Paid, it's going to be give you a little background about what we do. We have been offering educational courses that hope to bridge the gap between what is offered by the boards and what is offered by maybe your brokers, from a perspective of attorneys who maybe see some of the hiccups and issues in our real estate transactions. So we will go ahead and get started. I want to make sure that I give you the correct disclosure. I'm not sure I left my attorney disclaimer in here, which is my favorite. Oh, it is. It's in here. Okay. Here's our agenda for today. We're going to talk about the three updates, the three paragraphs in the FARBAR contract. When you're looking at the FARBAR contract, note you're going to pull the revision number 7. So at the very bottom, it's revision 7. It was revised December 2024. And then the Condo Rider, it's CR-7. Condo Rider, I also revised in December of 2024. For quick note, if you pull your forms from Form Simplicity, you can actually look in the far right column as to the last revision date of those forms that are available in the forms packet. And I will talk about the condo disclosures, the old disclosures that were required under Chapter 718-503, the old news, but also maybe we'll talk about who's responsible for providing those documents. We'll also talk about the FARBAR Condo Rider itself. The new disclosure language is going to be a challenge as we get through, asking our associations and property management companies new questions that they may not be prepared to answer yet, but it's critical for the seller to get the information to provide to the buyer. And Kristen's going to give us an NAR update on sort of the code of ethics and what we can expect coming down the pipeline. But before we get started, my favorite slide in the entire world is the disclaimer slide. So we are attorneys, but this is an educational forum. So our opinions here are our opinions for educational purposes. It doesn't necessarily reflect the opinions of the committees in which we serve, the Florida Realtors, Florida Bar, any of our local boards or associations. This is just an educational forum. Also doesn't create an attorney-client relationship. If you do desire legal representation or your client desires legal representation, they do need to hire counsel through a law firm. And here's our antitrust reminder. Again, this is a forum for the sharing of ideas. We're not going to participate in any communications, even in the chat, that would violate our antitrust laws. And I think that's all. Let's get started. So we're going to talk about the Florida Realtors, Florida Bar contracts. A quick overview for those of you who don't know, the Florida Realtors Florida Bar contract is prepared and revised by the Joint Realtor Attorney Committee that is made up of, I believe, 11 attorneys, 12 attorneys now, and 12 realtors and brokers. I think we're up to 12. And this contract subcommittee takes these suggestions from members, attorneys, consumers as to how we can tweak and revise the contracts and contract forms, and also takes information from litigation, from outside factors that will impact how we do our, how we do business and how we practice in Florida. All of that said, there are a number of forms that were released in this past year. Some of them were released by the Florida Realtors Florida Bar Committee, the FARBAR contract. Some were released by the Florida Realtors Forms Committee that are just Florida Realtors forms, not necessarily FARBAR contracts. And the reason I make this distinction is because, again, the FARBAR Committee is only responsible for the FARBAR contract plus the FARBAR comprehensive riders. And so how you know if you're looking at a FARBAR contract is at the footer, it'll tell you that it was approved by Florida Realtors and Florida Bar. And also, you'll know you're looking at version 7 of the FARBAR contract. So it's version 7 of the FARBAR contract that was revised December 2024. And with respect to the comprehensive riders, they'll all now say CR-7. A quick thing to note about the comprehensive riders, though, they will have the date that that particular form was last revised, even though it's a part of the packet that we now call version 7 of the FAR contracts. Not to confuse you too much, but just know that there is a difference. Florida Realtor Form contract called the CRISP contract. They also have Florida Realtors Form listing agreements, buyer broker agreements, compensation agreements, disclosures, commercial contracts, and that kind of thing. Those are all Florida Realtors forms. You'll note that they do not reference the Florida bar. So to the extent possible, let's not mix and match our forms, noting that when using the FAR bar contract, we're using FAR bar addenda. We are also in a revision year, so we did make some changes to the FAR bar contract, but we are undergoing our comprehensive revision of the contracts, and probably by the end of the year, there'll be some changes due to legislation, due to member input, and just ways to make the contract more clear for our consumers and balance between buyer and seller.
And I just invite everyone, if anyone's at Florida
Yeah.
Realtors, the FAR bar committee meets on Friday of the week at Winter Conference. I believe are we starting 9:30? I'll double check the time. It'll be in the agenda, but the forms meeting meets first, and then the full subcommittee meets later. If you attend either one, you'll get a pretty good update on what's going on in FAR bar land and what revisions we're looking at for 2025. And we always welcome your input. So feel free to come and listen and provide comments to us, because we listen to all of them. So come on over.
Yeah, we'll also be doing a sort of a lengthy presentation about how to deal with condos in 2025 and deal with the Condo Rider, and we'll have a couple of speakers as well. So, all right, let's dive into the Florida Realtors Florida Bar Contracts Revision, paragraph 19. This is an easy one, but I want to spend just a quick second on proper incorporation of an addendum to a sales contract. We've got two new checkboxes in paragraph 19 with respect to Rider FF and Rider GG that were released a couple of months ago, but now there is a checkbox to attach to the contract. Make sure when you're submitting an offer, as with any addendum, you're attaching the contract and checking the appropriate box. Attach and check the box to incorporate it into the contract. Also, a side note on our broker comp agreements, if you look in paragraph 19, you'll notice that there is not a space to add or checkbox to add broker compensation agreements, and that is intentional. Remember, the FAR bar contract and its addenda are designed to be executed by a buyer and by a seller, not outside parties. So your broker compensation agreements, whether that's between a listing broker and a buyer's broker or between a seller and a buyer's broker, those are executed by parties that are other than the buyer and the seller. So to recap, our FAR bar form, FAR bar addenda, two new addenda that were released this summer. Rider FF is a credit related to buyer broker's compensation, and Rider GG is a seller's agreement with respect to buyer's broker compensation. We'll recap what those are in just a second. The Florida Realtors compensation forms, not to be attached to the purchase contract. Two reasons. One, I just said it's not a FAR bar form, so it shouldn't be attached to a sales contract. And two, it is a compensation form that is executed by any party other than solely the buyer and the seller. So when we're talking about the CASB and the CABB, those are separate and apart agreements between different parties that are not the buyer and not the seller. Also, to recap where you can see the genesis of these forms and sort of the dates that they were released and explanations from Florida Realtors, go to floridarealtors.org and go to the CitraPronet site specifically to see where these forms were released. Rider FF is a credit related to buyer's broker's compensation. So on the form, we're going to include the name of the brokerage, the amount of the credit from seller to buyer. This is, again, credit from seller to buyer on the settlement statement towards the payment of buyer broker compensation. In the form, we need to determine if the credit listed on that addendum exceeds whatever the lender allows. Then you need to decide at that time, at the time of offer execution, who's going to get the balance? Is the balance going to be paid directly from the seller to buyer's broker, or is the credit reduced to whatever amount the lender will allow to appear on the settlement statement? Another friendly reminder, Rider FF as an addendum to a sales contract between the seller and a buyer does not modify a buyer-broker agreement. It does not modify a compensation agreement. And the reason is because those agreements are executed by parties other than a seller and a buyer. So nobody can unilaterally modify one of those compensation agreements without the other party signing it.
Yeah, if you can
Here's a
just
picture of the form.
opine
Yeah,
real
go.
quick.
Yeah.
We hear a lot that title companies are telling you to attach these comp forms. It's not proper. It doesn't, those comp forms from Florida Realtors do not go with the FAR contract. Only Riders FF and GG do. But that doesn't mean you can't provide those comp forms to the title company so
Yeah.
that they know how to pay you. I think that's perfectly reasonable, but
Yeah.
incorporating it into the contract is going to be problematic because realtors are not parties to that FAR contract. So when you're asked, hey, can you send me over your comp forms or include them in the packet? I don't know that that necessarily means it needs to be part of the contract. I think they just want that information.
Correct. Yes. Yeah. And by analogy, I asked folks, would you ever attach your listing agreement to your sales contract as an addendum? And everyone's like an emphatic no. Why would I ever do that? I'm like, exactly.
It's
Why
the same
would you
thing.
do that? So right. So the same thing, those compensation agreements between parties are not the buyer and the seller should not be attached. They will hopefully be executed prior to or at the time of contract execution, and you can provide them in the same email. But remember, the legal effect of checking a box and incorporating something into a sales contract, you as a buyer's broker or a listing broker do not want to be a party to the sales contract at all. Okay, so here's a picture of what the Rider FF form looks like. I've had some folks surprised that this form exists, and they said it would have been helpful a couple of months ago. Well, it has been out for a few months now, so now you know it exists. Let's talk about the scenario where this would apply. Let's say I'm going to submit an offer, and I call the listing agent, and I ask the listing agent, is there an offer of compensation from listing broker or seller to buyer's broker? And let's say they say no. But you, as the phenomenal negotiator you are on behalf of your buyer, you want to go ahead and submit that offer. And let's say the offer is a great offer and the seller would consider offering a credit from seller to buyer to offset all or a portion of the buyer's broker's compensation. With the sales contract, you would check the box and attach Rider FF requesting a credit from seller to buyer specifically towards the payment of buyer broker compensation. So on the settlement statement, it would be a credit that shows from seller to buyer specifically towards the payment of buyer broker compensation. Seller agrees, buyer gets a credit at closing, and they have to come to closing with less money. Rider GG, this is a little bit different, but also helps to navigate the situation where offers of compensation may not be, those compensation agreements may not be executed at the time of contract execution. They may not be available. I give the example of a buyer's agent trying to deliver an offer on a Friday night. The listing agent is out at dinner. They don't have the compensation agreement available, but the buyer's agent still wants to submit the offer, and they want to make sure that there is a compensation agreement executed by third parties that will offset the buyer's obligation to pay buyer broker compensation as listed in the buyer broker agreement. Okay, so in our seller's agreement with respect to buyer's broker compensation, this is a contingency. The contingency is a period of time for the either listing broker and buyer's broker or for the seller and buyer's broker to enter into a compensation agreement, separate outside agreement. And if they provide that executed agreement to the buyer and it's satisfactory to the buyer, then the buyer will proceed. If they don't receive, the buyer doesn't receive that compensation agreement, knowing that it's executed between the appropriate parties, then the buyer has the right to terminate the contract within that contingency. Okay, if the buyer fails to terminate within the contingency, just as with any contingency, if the buyer fails to terminate, then they're moving forward without consideration of that contingency. So Rider GG, this is what it looks like, is a contingency. It's a seller's agreement with respect to buyer's broker compensation. Similarly, buyer's agent calls listing agent on a Friday night and asks, is there an offer of compensation? And the listing agent says, well, yes, there's an offer of compensation. And the buyer's agent asks the next question, which is not the money question, it is the from whom question. Who's offering that compensation? Let's say it's the listing broker. And the buyer's agent says, great, can you provide me a copy of the CABB, compensation agreement, broker to broker. Listing agent is out at dinner. They say, I don't have the form available. Buyer's agent knows that they can submit the offer contract, attach writer GG, check the box, and attach writer GG to the contract and fill this out so that the buyer knows they have a contingency for the execution of that third-party outside agreement, compensation agreement between the listing broker and the buyer's broker that would offset the buyer's obligation to pay buyer broker compensation at closing. Did I cover it? I think I covered it. I think I did it. Okay. We are moving on to the FARBAR contract. This is our first revision to the FARBAR contract. We're going to talk about paragraph 15A, buyer default. Kristen, can you tell me the background and what language we don't see here anymore?
Okay, so this is the first change that you're going to see in the brand new FARBAR contract. FARBAR contract, I think we went over, you're looking for the revision date at the bottom of 12/24, which everyone gets a little confused because they said these came out in 2025. The revision date says 12/2024, but yes, they were released in January. So the first revision is, if anyone recalls what came after this buyer default paragraph, it now cuts off at pursuant to paragraph 16, proceed in equity or enforce the seller's rights under this contract period. There used to be a sentence here about retained deposits. That sentence or sentences basically said that in the event buyer defaults and the seller keeps any of buyer's deposit, and any of that amount was subject to be paid to a listing agent as in connection with a listing agreement. So if anyone has seen in the Florida Realtors listing agreement, there's a little section where you can address retained deposits so that a broker can get paid part of those deposit funds when a transaction is canceled by the buyer. The paragraph here would say that any amount withheld or sorry, not withheld, distributed to the listing broker would be shared then with the buyer broker. That has been deleted. Why that has been deleted? Because now in our new world, post-settlement, there can't be a presumption that the seller has agreed to pay the buyer's agent commission. And that agreement kind of presumed that those funds would be shared between listing broker and buyer broker, and that may no longer be the case. As we see now, there's a lot of flexibility and changes in how commission is being paid. And sometimes the seller is not going to be in a position where they're paying the buyer's agent anything. So it didn't make sense to have a retained deposits clause that presumed sharing of commission between the listing broker and the buyer's broker. So that has been removed. So just know that I don't know of a ton of situations where folks have enforced that clause. I've seen it a few times. But if that's something that you typically relied on when you were representing a buyer, just know that that's not available anymore. So if you...
But what is available?
What is available is the default provision in your buyer broker agreement. So if you're representing a buyer who has defaulted on a purchase contract and lost their deposit, you may have triggered the default provision in your buyer broker agreement. And you might be able to send an invoice for commission depending on what your buyer broker agreement says. So if you're in a situation where the buyer is truly in default, and I always say that it has to be a true default. It's not a termination during an inspection period or the termination under a financing contingency. It has to be a buyer who has not followed its contractual obligations, breached the contract, and has, as a result, lost their deposit. If you have one of those situations, you might be able to enforce your buyer broker agreement for commission depending on how it reads. Always consult with counsel to get an interpretation of your contract before you start sending big commission demand notices, but just keep that in mind. So this change didn't impact too many people, but I think it's an important change that needed to happen after the NAR settlement and the rule changes that the settlement imposed.
Yeah, and that doesn't change anything in the listing agreement. If you have a retained deposits clause in your listing agreement whereby the listing broker is entitled to some form of compensation if a buyer defaults, that still exists. Just now the listing broker doesn't have to split it with the buyer's broker.
Correct.
All right. The next section is paragraph 9, closing services. You'll note in paragraph 9, the section just above that, what you see here on the screen, it now lists it's sort of what the buyer is responsible for, what the seller is responsible for. You'll note in the buyer section and the seller section that each have their own closing services. So what this provision does, it clarifies as defined by Florida statutes that closing services are separate and apart from title services and the provisions of a title insurance policy. So we are defining the closing services as defined in the statute and making it clear in the contract where it wasn't clear before that each party shall bear their own closing services fees, settlement fees, payable either to the closing agent or to another provider as each party may select. Now, as someone from Southwest Florida, I see some folks from Southwest Florida here on the Zoom today. It is customary for a buyer and a seller to each pay their own closing services fees, because the philosophy being, why would a buyer want to be stuck with cleaning up some mess related to the seller's side of the transaction, and vice versa. Now, it is very clear after including this language, we want to make sure that we were avoiding a situation where a buyer is surprised at closing that they have to pay a closing service fee, or a seller is surprised at closing that they have to pay something for the 5 different notaries for the sellers that are across the country, at closing. When we were revising this provision, it was interesting to hear how different geographic areas around the state of Florida treated this old provision. And some were adamant that, of course, the person who pays for title has to pay for everything. And then in another geographic location, it was interpreted differently. That, well, no, each party is going to pay for their own closing services because those are separate and apart from title insurance. So now we have it very clear in the contract. If we go to line 172, it was modified to read that the seller shall designate the closing agent and pay for the owner's policy and charges, and buyer will pay the premium for any lender's policy and endorsements. And think in the back of your mind, and each party will be responsible for any closing services fee for their side of the transaction. Subparagraph 2, line 174, the buyer shall designate the closing agent and pay for the owner's policy and charges and premiums for any lender's title policy and endorsements. And again, in the back of your brain, think buyer and seller are still responsible for their own closing services fees to the extent that there are any. And Miami-Dade, if you practice in Miami-Dade, it is the sort of bifurcated process where the buyer is designating the closing agent and paying for the owner's policy, but the seller is going to be paying for the title search and the tax search and the municipal lien search. It's sort of a bifurcated process, but also buyer and seller are responsible for their own closing services fees. All right. Before I move on to condos, Kristen, was there anything else about the 5-bar contract that we want to make folks aware of? No, I think we're good.
No,
Okay.
I think the most important thing is to make sure you have the most recent copies.
Yes.
Sometimes we have a tendency, it used to be we printed them and put them in our drawer, but now I think we save PDFs on our desktop. So make sure that if that's the way you operate, instead of using maybe a transaction management software, that you download fresh copies and be on the look for Florida Realtors updates. Or just to be safe, always use your transaction management software. If you use a third-party software, double check, because they have a delay time in getting forms. So if you use app files, things like that, they're usually pretty quick. But because there's been so many form updates constantly, they were behind for a little bit from the feedback I got from clients. And that makes sense. I mean, we released a new Condo Rider October 1st and then again on January 1st. So we're not doing anyone any favors. Just double check that you have the proper forms and the most up to date.
Yeah, and just another note about the reason there have been so many updates. It is not because we love revising the forms, although Kristen and I do like to wordsmith, but it is because the law requires us to. So there was an updated Condo Rider back in October because there were 2 changes by law that required us to have new language. And similarly, the end of December this year, all contracts executed after December 31st, 2024 must have new disclosures required by law. So that's why there's a new Condo Rider that has a revision date of December 2024. Okay, what you see on your screen is not news, it's just a refresher. So we've got the condo docs that a buyer is entitled to receive by law, declaration of condo, bylaws, articles, rules and regulations, that elusive, frequently asked questions and answers document, the annual financial information, and I have highlighted in green because this is new to you if you have not sold a condo since October 1st, the budget. The buyer's entitled not only to receive the most recent year-end financial information, the annual financial information, but they're also entitled to receive the prospective budget. So if you have a listing that you took three months ago. Update the listing with the budget, because that probably has changed for 2025. Make sure you're updating the fees on the Condo Rider, and make sure you're using the new Condo Rider dated December 2024. Also, in paragraph 6, we have lumped in the DBPR condo governance form as one of the documents the buyer is requesting from the seller. DBPR condo governance form that you can save on your desktop at least for the next 7 or 8 years. It was last revised in October or in 2021. So make sure you can Google the DBPR condo governance form. It is not specific to any particular condo association, but it is rather generic and lets a buyer of a condo in Florida know if you're buying a condo, there will be rules and there will be fees. It takes a few pages to say that, but that is the gist of the form. So those are the documents that are required to be provided. Whose responsibility is it to provide? And I really feel good about this change that we made to the Condo Rider, because the statute says buyers entitled to receive. And anecdotally, we've heard from buyers agents and listing agents who are frustrated with each other, who say, well, it's your responsibility to provide it. Well, it's your seller, or it's whatever. Now it is very clear in the contract that it's the seller shall at seller's expense provide the buyer with the current copies of the condo docs. Seller shall at seller's expense provide the buyer with the current copies of the condo docs, which makes sense because the seller is the best suited person to obtain those documents to be able to provide it to the buyer. So my suggestion will be at the time of listing, or if you've got an old listing and you're updating it now, do it now rather than wait until you have an offer that's about to come in. Get the information, get the condo docs, make sure the seller is able to provide all of the condominium documents and provide them to the buyer. One quick thing, I put an asterisk here on the declaration of condominium. If you only sell one condo building, that is your building, that is your baby, and you have the declaration of condo from 1982 saved under your desktop, and you haven't updated the documents since then, update them. Make sure you get an updated version, because the declaration of condominium will likely have been amended. So any of the amendments that are recorded in public records also need to be provided to the buyer. And while I'm on this slide, for funsies, can you get the minutes and the agendas, maybe condo insurance, litigation information, to be able to complete the rest of Condo Rider A? Okay, so now it's clear. Seller shall provide. Paragraph 6, the buyer's either requesting the documents or they don't request the documents that are specified in paragraph 5. I don't know about you, Kristen, but I've never had a buyer receive all of the condo documents, all of them, at least 3 days, not including weekends or legal holidays, prior to contract execution.
But they have checked the box.
But they checked the box. Yeah. Yeah, chances are they have not received the documents. Chances are they're checking the box in paragraph 5 saying, I understand this contract is voidable within 3 days, not counting weekends or legal holidays, after executing the contract and receiving the last of those pieces of information, the last of the documents. Okay, your buyer is going to be in paragraph 6, checking to request the documents that are listed in paragraph 5 that we just went through. All right. I show this not so that you can read it and get busy, or not so that you can just completely tune out. Just know that this is the language from the statute, chapter 718, 503, sub 2, subparagraph E, that we had to wrestle with in the most recent version of the Condo Rider. It is very specific technical language that we're required to ask of a seller with respect to milestone inspections, structural integrity reserve studies, and turnover inspections for turnovers after July 1st, 2023. Very specific. And if you see the all caps language that's in the statute, that is also required to be in the Condo Rider, which explains also why it is 4 pages long and a bit confusing, but we're going to break it down and it's going to be easy, I promise. So just know we're going to have to ask, these are the new questions we're going to have to ask the association or property management company, or better yet, that your seller is going to have to get the answers to from the property management company or the association. Question 1 is whether a certain inspection is required for this association. And question 2, whether the report exists, whether your inspection has been completed and the report exists. Okay, those are the essential questions that we're asking. And since we are just in the beginning of a new year, make sure you're going ahead and updating your Condo Rider, update your listing with the new fees, the new budget, application information, property management company information, because those tend to switch around from time to time. Okay. Change it now, and then make sure you're updating it just prior to contract execution. Here's what the new language in the Farber Rider A, Condo Rider, revised, December, that should be a 12, revised December 2024. Here we got paragraph 10, with respect to milestone, turnover, and structural integrity reserve study. We'll ask the questions with respect to 10A, and then I'll show you how we're going to ask them for the other questions. So paragraph 10A, with the respect to the milestone inspection, we're asking the question whether the association is required to complete a milestone inspection and whether they have completed the milestone inspection. If the answer is yes, then paragraph 10A sub 1 is the box that the seller is going to check. We ask the association, are you required to complete a milestone inspection? And they say no. Paragraph 10A sub 2, you answer the question, is not required to have completed a milestone inspection. That is all you have to do. By you, I mean the seller. Paragraph 10A sub 3, let's say the association says, yes, we are required to have a milestone inspection by law, but we have not completed the inspection. Then the seller is disclosing, paragraph 10A sub 3, that they are required to, but they have not yet completed the report. Okay, so the questions are, is it required? Is it completed? And you're able to answer those questions for each of those types of inspections. The seller, again, is the best suited person to be able to get the answers, and the seller is the one who's required to provide the disclosure to the buyer. I have had an interesting question recently. Someone said, well, if I know for sure that this particular condo is not required to have any of these studies, can't I just use the old form? Can't I just use the previous version CR6 form? And the answer is no. And the reason why is because the statute requires the seller to provide this disclosure that the association is not required to have these 3 types of reports completed, or the seller is required to disclose that the association is required to have it completed, but they haven't completed it yet.
Erin, I might be jumping the gun, but I had this question come up, and I feel like we should scroll down. I keep getting the question, can the parties just waive the obligation?
No. What? No.
And no.
What?
And
no.
It says that in the disclosure. So I don't know if we can, no, we can't highlight a slide, but it's right there. She's pointing to it.
Am I? I was going to look at the statute itself. Wait, where?
It's okay. You got it.
Am I here? Waivable. Yep. Can't waive. Contract that doesn't
Any purported waiver of these voidability rights shall be of no effect. So you can try to get clever. Huh?
Yeah. Show me where I am. Where's the bottom of the screen?
Oh, you're right there. You're right there.
Oh, yeah. Oh, I'm on it. Oh, yeah. Yeah. Thank you. Yes. So, yes, Kristen, the answer to your question is no. Sellers can't force a buyer or try to force a buyer to waive the voidability. Buyer's entitled to void. Similarly, with the other condo documents, buyer can't be forced to waive receipt of those documents. It is of no legal effect here. And thank you for having me go back to this slide, because actually we need to talk about 2 sort of different concepts. Concept 1 is that the sales contract between the seller and the buyer needs to conform with the requirements of Florida law. If you look at the very fine print at the very bottom of the screen, you'll see it says a contract that does not conform to the requirements of this paragraph is voidable at the option of the purchaser prior to closing, which means you want to make sure your sales contract has the disclosures, has the new Condo Rider attached to it with the information completed. Sellers disclosing this information to the buyer in accordance with Florida statute. So that's sort of part 1. And part 2 is, to the extent the seller answers yes and yes to any of the questions, meaning yes, it is required, and yes, it has been completed. For example, if question with respect to milestones in 10A1, that box is checked, we know that the buyer is entitled to receive a copy of that report. Similarly, paragraph 10B1, if turnover inspection report is required for a turnover inspection performed on or after July 1st, 2023, think newer condos, buyer is entitled to receive the report. They're entitled to receive a disclosure saying there's a report, and also the report itself. Structural integrity reserve studies, whether the association is required to have it and whether they've completed it. And if they are required and they have completed it, buyer is entitled to receive a copy of the report. And we'll talk about those voidability rights. So just to recap, Farbar Condo Rider A, paragraph 10, we're answering questions. Is the association required to have this inspection? If the answer is yes, go to the next question. Has it been completed? If the answer is yes, then the document itself needs to be provided to the purchaser. So yes and yes equals some sort of document report that you're supposed to provide to the purchaser.
And what happens if you
Not
can't get the information?
What do you mean, what happens if you can't get the information? Buyer has avoidability right? Just as if you can't get a copy of the rules and regulations of the association, right? The old condo docs. Buyer has avoidability right after contract execution and receipt of that document. So I am concerned that we may be in a position that now buyers still have more rights to terminate the contract because the seller failed to provide either the proper disclosures or the documents themselves reflected as those disclosures required. We don't want our deals to blow up, but as Kristen knows, I love to say and love to hopefully scare people a little bit, say if a buyer wants out of a contract and they call an attorney, the attorney's going to ask 2 questions. Question number 1 is it within an HOA? This is the easy one, right? Is it within a homeowners association, meaning like a master association? And the answer is yes. The attorney is going to ask for a copy of that homeowners association disclosure summary, Rider B for Farbar. And they're going to review it and make sure that the association name is correct, the fees are correct, everything is properly completed and disclosed. If that information is incorrect, not properly disclosed, then guess what? The buyer has a right to terminate the contract, not because the attorney is a hero, but because the statute 720 says the buyer can terminate the contract because they didn't have the proper disclosure prior to contract execution. If the answer to the question with respect to the HOA disclosure is no, or let's say the HOA disclosure is fine, the attorney's going to go to the next question. Is this a condo? I mean, buyer will say, yes, this is a condo, and I don't want to buy this property anymore. We're a week before closing. The attorney's going to ask for a copy of the condo rider. If the buyer says there is no condo rider, buyer can terminate the contract because they didn't receive the appropriate disclosure language required by statute. If buyer says, yes, here's a copy of the condo rider, the attorney's going to say, great. It looks like you requested a copy of all of the association documents. Show me the documents that you have received. I will tell you the chances of a buyer having received all of these documents is so very slim. If the buyer hasn't received the rules and regulations, can the buyer terminate the contract, Kristen, the week before closing? No other contingency? Can they just terminate and get their deposit back?
You said if they don't receive what? The rules and regs?
The rules and regulations, yes, required by law. If the buyer hasn't received it, they can terminate, get their deposit back, walk away. Seller's already moved out of the house. Seller's very upset. They moved out of the house. Buyer can walk away. Buyer gets their deposit back. Okay, that is a way that the attorney looks like a hero. We don't want to blow up your deals, but if a buyer comes to us and says, I need an out, find me an out, I'm engaging you to find an out of this contract because whatever reason, they're going to look at the condo docs. So this is our sort of cautionary tale for real estate agents, whether you're the listing agent or the buyer's agent. Even though the contract says it's seller's responsibility to provide, chances are you may be in a transaction brokerage relationship and you want to make sure the deal moves forward and you want to make sure that the buyer's received all of the required disclosures and information so the buyer can understand whether they can actually afford to buy this home and that kind of thing.
And this is not a sneaky out. This is a legal right for buyers. So I understand the frustrations of terminating last minute, but at the end of the day, I think if anyone who has worked in condo sales over the last year, you know that buyers need to do their diligence on these properties because they don't want to be buying into a property with major assessments coming down the pipeline or major repairs coming down the pipeline. In some respects, these can be great buys in certain circumstances, but the buyer still needs to be informed. And the only way to be informed about all of these changes is to have these documents.
Yes. And I would say, in addition to these documents that are required by statute, thank you for the lead in, because I'm going to talk about the thing that gives me the most heartburn. I don't have a slide on it, but we're going to talk about it because I can't not talk about it. in addition to these documents that the legislature has decided is important for a buyer to receive, I also think a buyer should want to receive the minutes and the agendas for the previous 12 months. And I also think a seller should want to get those to be able to provide to a buyer. And I also believe, because in the Condo Rider, this is not new language. This is just language that unfortunately there are 3 lines in the Condo Rider in section C that are always left blank, and my heart breaks every time I see it left blank. It says, special section C, sub 1, it says sellers disclosing any special or other assessments that has been levied or pending the buyer. They're disclosing this, subsection 1. The lines are always blank, sellers failing to disclose them. And there's so much that has happened within the past year that can or will or is resulting in additional expenses to a purchaser. Sellers failing to disclose that section. But they are remembering, or they're negotiating with the buyer, that the next section, they check the box and say, buyer's going to be responsible for whatever assessments are levied after the effective date. However, the rest of that sentence says, to the extent the seller disclosed the stuff in paragraph 1, buyer can agree to pay for whatever is coming down the pipeline. But if the seller fails to disclose what's coming down the pipeline, pending, as reflected in the meeting minutes or the agendas within the previous 12 months, then the seller's on the hook for paying for it. That's paragraph 3. We're not making this up. And I will tell you, the folks who have to have the awkward conversations with their clients, it's usually us, closing agents. We get the estoppel. We find out that there's a special assessment that's due. It wasn't disclosed in the Condo Rider, but they have a provision that says that the buyer's going to pay it. So seller's like, well, buyer's going to have to pay for this. And I say, it says to the extent that this information was disclosed above in that provision.
And it wasn't.
If a seller fails to disclose it, even though they tried to negotiate to have someone else pay for it, they didn't disclose, so the buyer couldn't have been aware to actually negotiate in their interest. Seller has to pay for it. That is not a conversation you want to have the week before closing or 2 weeks before closing when the estoppels come in. It's a conversation you want to have at the time of listing with your seller to say, hey, we want to disclose whatever's coming down the pipeline, because whatever we disclose, we can negotiate and have the buyer take the responsibility for. If we don't disclose it, we will be on the hook for whatever's levied after the effective date. Right. Thank you for letting me step on the soapbox, you guys. I hope that 2025 is a year that I see no more Condo Rider A's that have blank lines. If there really is nothing, which I doubt it, but if there really is nothing, just put an A so I know that you looked the box. And then don't try to negotiate to have someone else pay for it, something that doesn't exist. Okay.
We have a question.
Okay, yeah, go for it.
Are all associations obligated to have all of the documents listed?
By Chapter 718-503, all of the well, actually, other places in Chapter 718, they're required to have all of the documents. Now, the DDPR condo governance forms, number 8 on the list, go to the website, go to the internet, you can pull that form down. That wouldn't be something that's listed. But yes, all of the associations are required to have all of the documents. And I know your follow-up question, Monica, is going to be, but they never have the FAQ. But the association says, well, we don't have the FAQ. They're required to, by law, have the information. So there is a form I'll send to you guys after our presentation. There's a form that DBPR has. It's just a blank Word document that is a request for information from the association to be able to answer the FAQ questions. It's available on the DBPR website. That I would send if I was requesting information to an association who says they don't have it. But here's the DBPR form. Oh, you're refusing to complete it, or let's talk to your attorney or whatever. It's a requirement by law. They have to update it every year. So there's a form to request that information. I think that's probably where she was going with it. The question she didn't ask is, does the association have to have this information on the website? And currently the requirement for condos is, I believe it's 125 plus units. They must have the information on a website that is accessible to a unit owner. In 2026, we'll see that requirement, the number of units drop down to 25. That was part of last year's legislation that was, I think, House Bill 1021, that required associations, smaller number of units, to have a website, but they've got some time to get their act together. But in any event, all of this information is available to a seller as a member of the association, as a unit owner. And again, if your seller says, I cannot be bothered with this, You can tell them my stories of woe of saying, listen, that's fine. If you don't want to get this information, just know that you could be 30 days into a contract and the buyer can walk away. Do you want to waste your time, your money, my time, my money, that kind of thing? So scare them a little bit. On the website, accessible to the public or owned unit owners. Monica, it's my understanding that only accessible to unit owners, but I can double check that in the statute, and I will send you a little clip or a little message after. But in any event, Monica, they should be able to go to the association and inspect the documents. There's a piece of paper you can submit to the association. You, meaning the seller, can submit to the association to make the formal request to inspect the documents. And again, by law, they have to comply, and there are enforcement mechanisms in the law that potentially could help. Now, if I was having a hard time getting information from an association, and this is not just because I'm an attorney, but if I have a hard time getting information from the folks who I think should have the information, I am not afraid to look on Sundays and find out if there's an attorney who represents the association and contact them and say, hey, listen, I need this information. So-and-so has requested it. They just want to get their deal done. Can you please point me to the right person, the right property management company? Because
They're usually willing to help.
That yes, they are, because they're their clients and they want to make sure they're also complying with the law. So again, I would maybe go onto Sunbiz, see who the registry agent is. Sometimes it's an attorney. You can contact the attorney and be nice to our property management companies too, because they're probably going to receive an influx of questions from listing agents, from sellers, and they may not be prepared to answer the questions yet. So we're going to be nice to them. We'll send them cookies. And if we don't get the answers that we're looking for, again, try to contact counsel and see if we can get a better way to get those answers. We know we've got these questions we're asking with respect to milestone. If required, if it is completed, deliver a doc to the buyer. And again, the buyer has a 3-day right of rescission upon receipt. That 3-day right does not include weekends or legal holidays. I have an asterisk there because we know that if the buyer receives the milestone inspection that is required and completed at least 3 days prior to contract execution, and I'm shaking my head because that never happens, but if they receive it prior to contract execution, fine, they don't have a right of rescission. Chances are you're in the second camp, right? The buyers receive the Condo Rider with this disclosure information on it, and sometime, hopefully between contract execution and closing, the buyer has received the document itself, received a copy of the milestone inspection, and the buyer has a 3-day right of rescission after that. Again, best practice, get the information at the time of listing, update it just before contract execution, get a copy of the document. You've got plenty of time. The worst thing for the seller and for the property management company really is to have a listing for 3 months, not do any updates, have the old form, have a buyer call on a Saturday afternoon, or buyer's agent call on a Saturday afternoon wanting to put in an offer. And they point out to you as a listing agent, hey, I see that you have an MLS, the old form for the Condo Rider, but I know we have to have these new disclosures. Can you please provide us the new rider? This is Saturday, okay? You haven't done haven't updated the form. You don't have the disclosure information. You certainly don't have the milestone or structural integrity reserved information handy, nor do you have the documents. So what do you do? If your buyer if your parties go under contract, knowing this information is still outstanding, let's say, or you're still negotiating the contract, the property management company at 8:30 in the morning on a Monday is going to receive a phone call from a very frantic listing agent who's trying to get information, and they may be upset. And I will admit, property management companies and associations do not receive the best of us. So let's be nice to them. Try to get the information in advance so we're not rushing and scrambling to get the information. Same questions for a turnover inspection report. Again, that is for your newer condos. Same questions for the structural integrity reserve study. If yes required, if yes completed, deliver the doc to the buyer. Those are the questions we have to answer. If the answer was yes, yes, and the document is required, we have another checkbox to include in our contract. And I'm not a betting gal, but I would bet that the Roman numeral I, that was the first one, the buyer hereby acknowledges that they've received it 3 days prior to contract execution, is not going to apply in your transaction because they have not. I guarantee it. They have not received the milestone inspection or structural integrity reserve study at least 3 days, not including weekends and legal holidays prior to execution of the contract. But subparagraph 2 does apply. Again, it's letting the parties know that the contract is voidable by buyer by delivering written notice of their intention to cancel within 3 days after receipt of the documents. Just But let's be to the very top of subsection D, though. It says check only one box. We can get that part below if the association has completed a milestone inspection or turnover inspection or a structural integrity reserve study. So again, if in our previous section, if any of the number ones, right, is required and has completed, is required and has completed, if any of those are checked, then you know that you have to provide the document for that item. And the buyer has a 3-day right of decision after receipt. Whew. Kristen.
That was a lot.
Actually,
so my update will be brief.
Okay, let me pause real quick. I'm sorry, I put the resources at the end and I wanted a little bit closer. You guys, these are fantastic resources. We will send you the slides. They are clickable links. Where I would live for the next couple of months as I'm trying to sort through the condo issue with the milestone and CSRS is go to DBPR's website. They have a special website that is very user-friendly. I would send it to my customers, send it to my sellers so they understand why I'm asking these crazy questions about milestone inspections and structural integrity reserve studies. But condos.myfloridalicense.com, they have FAQs, they have forms that you can provide. They actually even have an education section so you can hire them to come to talk to your association or to your brokerage about the inspections that are required, what some of the issues are, the timing, which associations are required to have them, where the database might live once they have completed them. Go to that second set of materials, DBPR materials, condos.myfloridalicense.com. It is fantastic. I have been texting it and emailing it to folks since I found it. Every time they ask a question, like, here, read this, here, read it. Because the statute is hard to read. I'll be honest, it's hard to read. But this provision, the condos.myfloridalicense.com, is great. If you do want to read the statute and you have a hard time sleeping tonight, go ahead and go to chapter 718.503. The first link, click on that. And then just sort of an overview where you can find the FAR reform updates. Go to floridarealtors.org, tools-research, far right corner. You're going to look at form updates. Again, you have to be logged into Florida Realtors to be able to access the form updates. But generally, when they release a new form, they'll give you a description of what the form is and what it does. And not as comprehensive as ours doing today, but it's at least an overview of what is coming, or has been released. And if you practice in Southwest Florida, Neighbor has a similar site, Neighbor Realtor Tools, where you can see the Neighbor contracts in most recent versions. And of course, video replays for us, Get Closed, Get Paid, commissiondisputes.com. We also have a YouTube channel. Kristen, I'm sorry, back to you. NAR updates. Tell me a little bit about that.
Okay, so we were expecting a new code of ethics in 2025. There is a new code of ethics out, but it doesn't have the sweeping changes we were kind of anticipating. After the NAR settlement and all of the changes related to buyer representation and the changes to the MLS and the way in which offers of compensation flow from a seller to a buyer, seller's agent, sorry, to a buyer's agent, we thought that there would be more changes, especially related in the code of ethics to some of the concepts of cooperating brokers and things like that. We haven't seen those widespread changes yet. So maybe later on in the year, that's a big overhaul. So I'm hoping that that's just still in the works and coming through the pipeline. But the few changes that we do have that I'll go ahead and review with you. One change was to Article 4. For anyone who doesn't know what Article 4 is, Article 4 references the requirement to disclose when you are representing when you're trying to buy a property for yourself. So there's a rider for this, but it's the idea that when you're buying something for yourself, you're going to disclose as an agent that that you're interested in buying this property. That language was refined. It now reads, realtors who have a present ownership interest in the property for sale or lease, or a contemplated interest to purchase the lease or lease property must disclose its existence in writing. So that kind of shows that whether you're working with the seller or the buyer, whether on your own behalf, so you're selling your own property, or you're representing a buyer who's trying to buy something for their own interest, you have to disclose in both of those scenarios. It also defines kind of what situations. Go ahead.
I was just going to pull up the Condo Rider, the Farber Rider that deals with licensing.
Oh, yeah. Sorry, go ahead. And I'm going to drop these changes into the chat. Hold on.
Okay.
Yeah. So I don't know if this is going to change. We probably need to look at this, but right now it says the new definition of present ownership interest was defined to mean you're either representing yourself, you're representing a member of your immediate family, you're representing their firm or broker, or you're representing an entity in which the realtor or a member of their immediate family has an interest. So you've got the LLCs, the trust, those type of situations where the actual owners of those are the licensee that's handling the transaction. So be aware of that. The other big change, did you bring it up on the screen? No, not yet. Okay.
No,
Oh,
sorry.
no. I thought you might. That's okay. The other change that you want to note is there was a change to the professionalism article that talks about permission before photography, doing photography, video, things like that in another agent's listing. It actually says that there should be permission obtained from the listing agent before you start to film and do those things inside their listings. So be a little conscious of that.
Oh,
There's a lot of language in the Code of Ethics that protects the materials that are developed by listing agents, which makes sense. Your job, a big part of a listing agent's job is marketing the property. And if they have the exclusive right to do that, you want to kind of protect those interests and the marketing materials that they create. The other changes actually go to kind of the Code of Ethics, ethics complaint arbitration process. So timelines, how filings are made, how appeals are done through both an ethics hearing or an arbitration hearing through the Board of Realtors. There's been some tweaks on those timelines, tweaks in the process made, tweaks in how you define how the statute of limitations, it's not called a statute of limitations, but that's effectively what it is calculated, things of that sort. So generally, Code of Ethics issues, arbitration matters, nobody really needs to know about until it becomes an issue. So my recommendation is if you think you have an ethics issue, or if you think you need to file an arbitration because of a commission dispute, early reach out to your local board to get their arbitration packet because it's probably changed. Get the most recent form of their arbitration packet because these changes may necessitate a change in their forms. And then take a look at those timelines and make sure you're calculating things correctly. Like from closing, how many days do you have to file depending on the issue at hand? So just take a look at that. But once you get that updated arbitration packet, you should be able to have all the information that you need. Just know that those changes are happening. And like I said, we anticipate there's going to be a lot more changes because at the end of the day, if there's an issue of commissions between brokers, that's something that usually would go to a Board of Realtors arbitration matter. And that could happen quite a bit in the environment that we're in. So those are the changes. Oh, I didn't know you added that last little part.
just just a quick note. We followed the Sister Burnett case. We've been following a lot of the NAR cases and DOJ cases. So the breaking news as of yesterday was that the Supreme Court did deny NAR's appeal of denial of rehearing versus the DOJ, which means that the DOJ may continue to investigate or reopen its investigation with respect to clear cooperation and some of their other policies. So just something to pay attention to, something to note when, sorry.
Have we reported since it got final approval? I feel like that happened on the eve of a holiday.
That was the day after Thanksgiving. I think we have, I
don't know if we did. Because we jumped into condo land. So yeah, so the settlement agreement was approved. That was pending settlement until I think it was Thanksgiving. I was like, it was either Thanksgiving or Christmas. It was a holiday. Because I feel like at the end of the hearing, the judge said, and everyone go celebrate the holidays.
Yeah.
It did receive final approval, but DOJ is still waiting in the wings. That would be the summary that we have at the moment. There's also still litigation out there in other areas. So while those seller claims have been resolved, there's still other litigation out there. There's also some litigation out there related to rentals now. So to be determined, we follow it. We follow it the best we can.
Also,
they did name it winners and losers in far bar lawsuits. I was totally kidding, but now I like it.
I love it. I love it so very much. No, so our next class, so save the date for Tuesday, February 11th, 2025 at 10 a.m. We will talk about some of the FAR bar cases. Another touchy title would be like how to not get sued using a FAR bar contract, but just know that there are a number of FAR bar cases that are instructive. Instructive on the one hand as to how folks are misusing the contract or sloppy work is resulting in some lawsuits, but also just how the court has interpreted some of the provisions in the contract. And there are a number of cases that we can talk about with respect to FAR bar. And then as we move forward, we are going to be setting our schedule for 2025. And we do like to alternate between nerdy contract legal topics and more fun topics that are relevant to you, whether it's marketing or lead generation, that kind of thing. So if you have any, I'm going to pause, but that is not our expertise. So we bring in a special guest to talk about things that are not legal in nature. So if you have any suggestions of folks that you think we should have on to discuss with you, please let us know. We're happy to bring them on. But again, we meet the second Tuesday of the month from 10 a.m. until 11 a.m. by Zoom, and our classes, of course, are recorded for you. I do have a couple of final comments. We did talk a little bit about the settlement and moving forward. And if you are getting your legal advice from Facebook, don't do that. And also make sure that you're being patient with the buyers who maybe aren't familiar with the process, maybe aren't familiar with the value of a real estate agent. And if a buyer says, I do not want to work with a real estate agent, there's an opportunity to suggest alternatives, okay? The buyer doesn't want to work with you as the listing agent. They don't want you to work on both sides. You can always refer them to other real estate agents, other brokerages to help them through the transaction. You can also suggest they reach an attorney to be able to guide them through the transaction, to explain some of the legal terminology. Just be aware of, I've heard of many buyers who are sort of on the fence about whether they want to engage counsel. And if you have the listing, you want to make sure that you are complying with your requirements, either to get a buyer broker agreement signed when you're going to be performing services for a buyer. You're going to be, again, providing services for a buyer, or have some sort of suggestion that they reach counsel or work with a real estate agent. Yeah, I think that's it. We're not going to skirt the rules. That's all I got. Okay, Kristen, if you want to stop the recording, then we will take some questions from folks who might have a few extra questions that maybe don't want to be on record, and then we will adjourn.